Elijah Hartwell walked out of the courthouse with nothing but the clothes on his back. His wife Diana had taken the house, the savings, the business shares he'd spent a decade building, and the judge had let her. Everyone told him to move on. So he did. He rebuilt quietly, from the ground up, accepting that some losses were permanent. Then, 18 months later, a certified letter arrived from a law firm he had never heard of. Inside was a single page. His estranged father, Joseph Hartwell, had died and left Elijah $50 million. And Diana was already watching. Stay until the very end of this story, because what Diana did next will leave you completely and utterly speechless. Elijah Hartwell sat at a small table in a rented apartment on the east side of Bridgeport, turning a sealed envelope over in his hands without opening it. The return address read Whitfield & Associates, Estate Law, Denver, Colorado, a name he had never encountered in his life. The apartment itself was modest to the point of austerity. Second-hand furniture, a kitchen with 2 mismatched chairs, a single window that looked out onto a parking lot. 18 months earlier, he had owned a 4-bedroom house in the Westfield neighborhood, a shared savings account with $380,000, and a company he had spent a decade building from nothing. Now he had a table, 2 chairs, and an envelope he was afraid to open. He set it down and made coffee first. 12 years before that morning, Elijah had been 26 years old, newly licensed as a civil engineer, and entirely unprepared for the way Diana Caldwell walked into a room. They had met at an industry networking event in downtown Chicago. She was a financial analyst with a sharp mind and a precise way of speaking that he found both intimidating and compelling. Their courtship had been unhurried, grounded in practical conversations about careers and goals and the kind of future they each expected. By the time they married, Elijah was 30 and Diana was 28, and nearly everyone who knew them agreed they were well matched. What no one said, because no one thought it, was that the match was not between 2 people in the ordinary sense, but between a plan and its subject. The early years were, by any honest measure, good. Elijah poured his energy into his work, and Diana, still at the financial firm, still sharp and composed, managed the household accounts with a precision that he found reassuring. In the 5th year of their marriage, he and a college friend named Owen Cole founded Hartwell & Cole, a civil engineering and construction consultancy. The company grew faster than either of them had projected. By year 8, Hartwell & Cole had a staff of 31 and a client roster that included 2 municipal contracts. Elijah's stake in the company, valued conservatively, represented the largest single asset he had ever held. It was around the 6th year of their marriage that he first noticed Diana changing, though he would not have used that word at the time. She traveled more, citing client meetings and industry conferences that he had no reason to question. She became quieter at home, not cold, exactly, but economical in a way she had not been before. Elijah attributed it to stress, to the natural rhythm of 2 people who worked long hours and had built separate professional lives. He told himself that this was what sustaining a marriage looked like, and he believed it because he wanted to. What he did not know was that during one of those conference trips, Diana had sat across a dinner table from a man named Adrian Voss and discussed Elijah Hartwell's financial position in clinical, unhurried detail. There was one conversation Elijah would later return to many times. Diana had asked one evening about his father, Joseph Hartwell, a man Elijah had not spoken to since the age of 24. The estrangement had come from a dispute over a family business, a decision Joseph had made without consulting anyone, and a breach of trust that had hardened, the way such things do, into permanent silence. Elijah told Diana the outline of it. Diana listened, asked a few careful questions, and let the subject drop. He thought nothing of it. He would spend a considerable amount of time later wondering how many searches she had run on Joseph Hartwell's name in the days that followed. The evening Diana placed the divorce papers on the kitchen table, she did not cry and she did not raise her voice. She set the documents down, said that she had retained legal counsel, and walked out of the room. Elijah stood in the kitchen for a long time, looking at the papers without touching them. What struck him was not the fact of the divorce itself. He had felt the distance between them growing for years and said nothing. What struck him was how prepared the paperwork was. Every page precise, every exhibit labeled, every argument anticipated. This had not been decided last week. This had been decided a long time ago. Diana came to the courtroom with 3 attorneys and Elijah came with one. His lawyer was Carter Brooks, his closest friend since their first year at Northwestern, now a civil litigator with a good reputation and no background in matrimonial law. Elijah had retained Carter not because he thought Carter was the optimal choice, but because Carter was the person he trusted most. And in that moment, trust had felt more important than strategy. He would recognize later that Diana had counted on exactly that calculation. She had not hired 3 attorneys because she was angry. She had hired them because she had planned this with the same methodology she applied to everything else. The argument Diana's team presented was not a simple division of marital assets. It was a structured legal theory built across multiple exhibits, supported by documentation that Elijah could not immediately account for. Diana's attorneys argued that she had made substantial indirect contributions to the growth of Hartwell and Cole, that her management of household finances in the early years had freed Elijah to build the company, and that her professional advice on investment decisions in their shared accounts had materially supported the firm's early capitalization. The argument was not outrageous, but it was aggressive, and it had been assembled with care. Carter pushed back on several points, but he was working without the preparation time that Diana's team had clearly enjoyed. The document that changed the shape of the proceedings was a 2-page internal agreement from the early years of Hartwell and Cole. On its face, it appeared to acknowledge Diana's role as an informal financial advisor to the company, a role that, if accepted by the court, would dramatically expand her claim on its value. Elijah looked at the document and recognized his own signature, but the context was wrong. He told Carter that the agreement had been drafted during a period of restructuring and had not meant what Diana's attorneys now claimed. Carter challenged the exhibit but needed time he did not have, and the court was not inclined to delay. What neither of them knew was that the date on the document had been changed. What neither of them knew was that the original, with its correct date, still existed in a filing cabinet at the State Business Registry office. There were no children to contest. That, at least, Diana had never wanted. The judge reviewed the claims, the assets, and the competing arguments over 3 days. The final ruling awarded Diana 55% of Elijah's stake in Hartwell and Cole, a percentage large enough to make his remaining position untenable, effectively forcing a buyout at a valuation he had no leverage to negotiate. She received the Westfield house. She received $280,000 from their joint accounts. She received the vehicle and a settlement structure that gave her legal claim to any appreciation on the company's value for the following 18 months. Carter called it aggressive. The word Elijah used, alone in the parking structure below the courthouse, was different. He did not break down in the car. He sat there for 11 minutes, which he knew because he watched the clock on the dashboard, and then he drove to the apartment he had rented the previous week. Carter called that evening and they spoke for 40 minutes. Carter was angry in the way that lawyers get angry, dissecting the proceedings and identifying the moments where different preparation might have changed the result. Elijah listened and said very little. He was thinking about something smaller, the way Diana had carried those documents, not in a briefcase. In an accordion folder, organized by tab, with color markers at the edges of the most important exhibits. She had been carrying that folder for a long time before she ever walked into a courtroom. Within 60 days of the ruling, Diana's team initiated the process of forcing a sale of Hartwell and Cole. The company Elijah had built for a decade was sold to a regional construction holding group at a price that reflected a motivated seller under time pressure, considerably less than what it was worth. Elijah received his proportional share of the proceeds, which after legal fees and taxes left him with enough to clear his remaining debts and very little else. Owen Cole sent a message that said only, "I'm sorry, I didn't know this could happen." Elijah wrote back, "Neither did I." He meant it as a statement of fact. He was beginning to understand that not knowing in this situation had been the whole point. The 18 months that followed were not dramatic. There was no public collapse, no visible unraveling. Elijah simply contracted, the way a person does when they are removing everything non-essential. He took on project consulting work, site assessments, structural reviews, permit applications for small developers who needed a licensed engineer but not a full-service firm. The work was competent and unglamorous, and it paid enough. He made coffee at home in the mornings, answered emails from a corner of the apartment he had cleared for a desk, and did not talk about Diana to anyone who had not already heard it from Carter. Carter came by on occasional Sunday evenings with takeout and sometimes information he thought Elijah should have. It was Carter who told him that Diana had sold the Hartwell and Cole acquisition interest at a profit 8 months after the forced sale, having held it just long enough for the new owners to announce a municipal expansion that increased the company's valuation by nearly 40%. It was Carter who mentioned without editorial comment that Diana had moved into the Westfield house with Adrian Voss, a man Carter had begun looking into with a quiet persistence he described simply as due diligence. Elijah received these updates with the same composure he applied to everything else. He had decided at some point he could not precisely identify that sustained anger required a continued investment in the person who had caused the injury. He had nothing left to invest. He was sorting through a storage box one Thursday evening when he found the photograph. It had been taken at a family gathering when Elijah was 7 years old, and in it he stood beside his father, both of them squinting into summer light. Joseph Hartwell was a tall man with precise posture and an expression that managed to look both proud and guarded at the same time. Elijah studied the photograph for a longer moment than he intended. He and his father had not spoken in 14 years. The estrangement had calcified slowly, not with a single catastrophic event but with years of misunderstandings and silences that eventually became permanent positions. It was the kind of distance that feels like a decision until enough time passes and it starts to feel like geography, like something that simply exists between two places with no one responsible for the gap. He put the photograph back in the box and told himself he had not thought about it again that night. He was not entirely sure that was true. What he did not know was that 212 miles away in a hospital room in Denver, Joseph Hartwell was signing a document. His hands were unsteady from the medication, and the effort of writing his full name in the signature line took considerably longer than it once would have. A lawyer named Samuel Whitfield stood beside the bed, patient and professional, holding the document steady. When the signature was complete, Joseph set down the pen and looked at the ceiling for a while. He told Whitfield that he hoped it was not too late to be useful to someone he had failed. Whitfield told him it was not. Joseph died 11 days later in the early hours of a Wednesday morning with no immediate family present. Elijah learned none of this until a Tuesday morning 7 weeks after Joseph's death, when a postal notification arrived informing him that a registered letter was waiting at the distribution center and required his signature upon pickup. He drove there before work. The envelope was heavier than he expected and bore the return address in a typeface that felt institutional and deliberate. Whitfield and Associates, Estate Law, Denver, Colorado. He signed for it, carried it to his car, and sat there with it on the passenger seat for a full 4 minutes before pulling out of the parking lot. He did not open it there, he drove home first. He set the envelope on the kitchen table and stood across the room from it, which he recognized even in the moment as a strange thing to do. Then he made coffee, because making coffee was something he understood how to do. The cover letter was formal and precise. It identified Samuel Whitfield as the executor of the estate of Joseph Raymond Hartwell, deceased, of Denver, Colorado. It stated that Joseph had passed away 49 days prior following complications from cardiac failure. It stated that, pursuant to a legal will prepared and notarized 6 months before Joseph's death, well after Elijah's divorce had been finalized, the entirety of Joseph's estate was to be transferred to his sole surviving son, Elijah James Hartwell. The estate was valued, after taxes and legal fees, at $50,200,000. Elijah read the paragraph twice, then a third time, moving his finger along each line to keep his place. Then he put the letter down and looked at the wall. He called Carter at 7:43 in the morning. Carter answered on the second ring, heard the first sentence, and said he would be there within the hour. He arrived in 50 minutes. They sat at the kitchen table with the documents spread between them and went through everything methodically. The will, the legal certification, the estate valuation summary, the transfer authorization, and each document held up exactly as it appeared. The will had been drafted by a licensed estate attorney, properly witnessed and filed with the appropriate court in Denver County. There was no ambiguity in the language. There were no other named beneficiaries. Joseph Hartwell's entire estate, accumulated over a lifetime in commercial real estate investment, passed without condition or complication to Elijah. At the bottom of the cover letter, a handwritten note in the margin directed Elijah's attention to a second item in the envelope, a folded page of cream-colored stationery. It was a letter in his father's handwriting. The penmanship was labored and slightly uneven, the hand of a man writing with considerable effort, but the words were clear. Joseph wrote that he had spent a long time understanding what he had done wrong, and longer still accepting it. He had followed Elijah's life from a distance. He had watched the marriage, and then the divorce, and then the aftermath. He wanted Elijah to know that he was proud of him, not for the company or the money, which were secondary, but for the manner in which he had conducted himself through things that would have broken a lesser person. And then Joseph had written, "There is a second document. Ask Samuel Whitfield for the sealed envelope. Do not do this by phone. Go to Denver." Carter looked at Elijah across the table. Neither of them spoke for a moment. Outside, the sound of a delivery truck backing down the street, a dog barking somewhere, the ordinary noise of a morning that had become something else. Elijah said he would need to book a flight. Carter said he would come. 20 minutes after Carter left to go home and change, Elijah's phone vibrated on the table. It was a text message from a number he did not recognize. 4 words only: "Congratulations, Elijah, D." He stared at the message and read it again. He had not told anyone about the envelope. He had called only Carter on a private line less than an hour ago. The question of how Diana already knew was not a small one. It was, in fact, the only question that mattered. He turned the phone over and looked at the message a second time. It was not a threat. It did not ask for anything. It was, if anything, worse than a threat. It was a signal. Diana was telling him she was aware, and she was doing it calmly, which meant she was not panicking. She had known or suspected something about Joseph's estate before Elijah had. How long before, he did not know. But the message told him that she had a plan, that the plan was already in motion, and that she had sent those 4 words at the exact moment she calculated would unsettle him most. He picked up his phone and called Carter back. He said 3 words. "She already knows," Carter said, "then we move fast." They moved fast, but Diana moved faster. 2 days after Elijah received the estate notification, a formal legal motion arrived at the offices of Samuel Whitfield in Denver. It was filed by Hale, Voss, and Partners, a mid-sized firm with offices in Chicago and Denver, co-founded by Adrian Voss, whose name appeared on the firm's masthead in the second position. The motion requested an emergency hold on the distribution of Joseph Hartwell's estate, pending resolution of a civil claim brought by Diana Caldwell Hartwell. Elijah read the filing in Carter's office and recognized its architecture immediately. This was not improvised. This had been prepared in advance. Diana's legal theory was barely viable, but barely viable was all it needed to be to cause damage. Her attorneys argued that because Joseph Hartwell had reportedly begun discussions about his estate planning during the period when Diana was still legally married to Elijah, any reasonable expectation of inheritance on Elijah's part during the marriage could constitute a form of marital asset, an anticipated financial event that should have been disclosed and considered in the original divorce settlement. They did not argue that Joseph's money belonged to Diana outright. They argued, with precisely calibrated modesty, that $12 million represented a fair adjustment for the portion of the marriage during which this expectation had theoretically existed. The number was not random. It was large enough to matter and small enough to appear reasonable. Carter pulled apart the legal argument the same evening. He explained to Elijah that the theory rested on a foundation that most courts would reject: anticipated inheritance, particularly from an estranged parent who had not communicated any such intention to his child, did not meet the standard threshold for marital asset classification under federal or Illinois state law. More critically, Joseph's will had been finalized after the divorce was complete. The argument was designed not to win but to create a freeze, to hold the estate in legal limbo long enough to give Diana leverage at a negotiating table. Carter had seen the strategy before. It was effective precisely because it weaponized the slowness of civil proceedings. Adrian Voss appeared publicly 2 days after the filing. He gave a brief statement to a local news outlet, expressing what he described as serious concerns about the timing of the estate preparation and suggesting, without specificity, that the circumstances warranted scrutiny. He used the word transparency twice. He did not make accusations. He did not need to. The statement was designed to attach a cloud of ambiguity to the estate, and it succeeded in the way that such statements always do. Not by proving anything, but by planting a question. Elijah read the statement in a document Carter forwarded. He noticed that Voss had not used Diana's name once. The precision of that omission was its own kind of communication. It was Carter who brought Grace Monroe into the picture. Grace worked at the County Business Registry office in Cook County, where she had spent 11 years processing corporate filings with a thoroughness that most people in her position had long since abandoned. Carter had contacted her as part of his general review of the Hartwell and Cole corporate history, asking her to pull the original filing records from the company's restructuring period. Grace had pulled them and found something that stopped her. The internal agreement Diana had presented at the divorce proceedings, the 2-page document with Elijah's signature, was on file in its original version. The original showed a date that was 14 months later than the date on the document Diana had submitted to the court. 14 months in a document whose entire legal significance depended on when it had been executed. Grace had flagged it as anomalous and set it aside, not knowing what to do with it. When Carter called and described the document, she knew exactly what she was looking at. Elijah sat in Carter's office and listened to this explanation with a stillness that Carter recognized as a particular kind of focus, not calm but controlled. He asked 2 questions. First, was the discrepancy provable in a court of law? Carter said yes, because the original filing carried a date stamp from the registry office's own system which could not be retroactively altered. Second, was this enough to constitute fraud? Carter said yes, and probably more. The word probably had a weight to it that expanded in the room. Elijah told Carter he wanted to go to Denver, not to file anything, not yet, but to collect the sealed envelope his father had mentioned. Whatever Joseph had left in that envelope, he had left deliberately, had paid to have it secured and stored, and had written about it with the quiet urgency of a man who had very little time and understood exactly what he was setting aside. The offices of Whitfield and Associates occupied the second floor of a converted brownstone in a quiet part of Denver that looked as though it had decided at some point not to be in a hurry about anything. The waiting room had leather chairs, framed topographic maps on the walls, and the particular silence of a place that handled other people's last arrangements. Samuel Whitfield was in his mid-60s, a lean, deliberate man who spoke the way careful lawyers speak, in complete sentences with no wasted words. He shook Elijah's hand, acknowledged Carter with a nod, and led them into his office without small talk. He had been expecting them. The sealed envelope was on Whitfield's desk. It was larger than Elijah had imagined, the size of a legal portfolio, sealed with both a wax impression and a strip of tamper-evident tape across the back seam. Whitfield set it in front of Elijah and remained standing. He said, "Your father paid a considerable amount to have this prepared, secured, and held. He said to tell you that you would know what to do with the contents when the time came." Elijah looked at the envelope. Carter looked at Elijah. Whitfield stepped back and let the moment exist without filling it. Elijah broke the seal. Inside the outer envelope was a bound document, 47 pages, printed and tabbed, with a cover sheet identifying its origin as Sentinel Investigative Group, Chicago, Illinois. The document was a private investigation report. The date on the cover was 4 years before the divorce. Elijah held the cover page for a moment before turning to the first tab. Carter leaned forward in his chair. The report opened with a section on Diana Caldwell's financial history prior to her marriage to Elijah. What it documented was not a conventional biography. It documented a professional relationship, ongoing, financially structured, and deliberately concealed, between Diana Caldwell and Adrian Voss that predated the marriage by at least 3 years. Voss, the report explained, was not simply a man Diana had become close to after the divorce. He was a financial consultant who had operated for years on the edges of legitimate advisory work, and who had developed a practice of identifying individuals in the early phases of building significant private wealth. The report described, with transaction records and communication summaries attached as exhibits, a structured arrangement targeting Elijah Hartwell as a financial subject. Diana had known who he was before they met. Elijah's name appeared in the scheme's intake documentation. He turned the page. The second section addressed the internal agreement from the Hartwell and Cole restructuring. The report's investigators had obtained the original filing from the Cook County Business Registry and compared it, line by line, with a second version they had separately acquired. The dates did not match. A forensic document analysis, performed by a certified examiner, concluded that the version with the earlier date had been produced using the original file template, with the date field altered by digital manipulation. The alteration was not consistent with retyping or reprinting. It required access to the original digital source file. The report noted, without elaborating, that Diana had worked for 3 years in an office suite adjacent to the one where Hartwell and Cole's early incorporation documents had been stored on a shared internal drive. It noted this once. It did not need to say it twice. The third section documented, through financial records sourced from a bank that had since merged with a larger institution, a series of wire transfers made from Hartwell and Cole operating accounts during the final 4 years of the marriage. The transfers were small, ranging between $4,000 and $9,000 each, and moved through 2 intermediary accounts before arriving in a holding company registered in Delaware under a name bearing no obvious relation to either Diana or Voss. The total across the documented period was $231,000. The holding company had been dissolved 18 months before the divorce. The money had dispersed into accounts the investigators could trace to within 1 step of Voss's personal holdings, but no further. The report described this as a structural limitation of the investigation and recommended further legal action. Elijah read the sentence twice. The money had been moved while they were still married, while he had been building the company, while he had been trusting the numbers. Elijah read the 47 pages in full. It took him over an hour, and during that time neither Carter nor Whitfield spoke. Whitfield refilled the coffee cups once. Elijah turned each page without comment, with a quality of attention that Carter recognized from the few times he had seen Elijah genuinely absorb something serious. When Elijah reached the last page, he set the report on the desk and looked at the window. Outside, a street lamp was just beginning to register against the early evening sky. He sat that way for several minutes without moving. Then he asked a single question. He asked how long his father had known. Whitfield answered without hesitation, "Long enough to make certain you would have everything you needed to fight back." Joseph had initially commissioned the investigation because he had developed concerns about Diana's financial behavior. Concerns he had arrived at through his own professional networks in the commercial real estate world, where Voss had operated on the periphery for years. He had spent 2 years building the report. He had never shown it to Elijah because, as he had told Whitfield, he did not know whether Elijah would receive it as help or as an intrusion, and he had been afraid to risk the latter. He had chosen to protect from a distance and leave the decision to Elijah when the time was right. Whether the time had been right before Joseph died was a question no one in the room attempted to answer. Elijah looked at Carter. Carter looked at the report on the desk. He picked it up, held it for a moment, and said, "This is not just leverage, this is criminal fraud." Elijah nodded once. He stood up, thanked Whitfield, and picked up his jacket. Outside, it had grown fully dark. He stood on the sidewalk in front of the brownstone for a moment before getting into the car. Carter stood beside him. Neither of them spoke. There was nothing that needed to be said. The report had said it, 47 pages of it with exhibits. Carter filed the response to Diana's estate motion within 72 hours of their return from Denver. The response was 2 documents, a legal brief demolishing Diana's marital asset theory, and a separate civil complaint alleging fraudulent misrepresentation, procurement of a judicial ruling through falsified evidence, and breach of fiduciary duty arising from the unauthorized transfer of funds from a jointly held business. The complaint was accompanied by an exhibits package that included as its centerpiece the forensic document analysis from the Sentinel report and a certified copy of the original Hartwell & Cole filing obtained directly from Grace Monroe at the Cook County Registry Office. Carter had spent 48 hours refining the filings without sleeping more than a few hours. They were precise, they were correct. They named specific individuals by name. And they contained, in their exhibits, 47 pages of documentation that a private investigator had spent 2 years assembling at the direction of a dying man who had wanted to make sure his son would not be left defenseless. The immediate effect was visible within 4 days. Diana's attorneys had filed their estate motion with the expectation that it would generate procedural delay while they assessed Elijah's position. What they received instead was a counter-offense that placed Diana personally in legal jeopardy. The fraudulent document claim was not about money. It was about criminal exposure. If the altered date on the internal agreement could be proven in court, and the forensic analysis indicated it could with reasonable certainty, then what had appeared to be aggressive but legitimate divorce litigation became something that could carry consequences no civil settlement would resolve. Diana's lead attorney requested an extension on all pending matters, which courts routinely grant and which Carter routinely opposed, documenting each opposition carefully for the record. Grace Monroe provided a certified declaration attesting to the discrepancy she had identified in the registry records, the process by which she had preserved the original filing, and the chain of custody of the document from the date of its initial filing to the present. Her declaration was precise and clean, the product of someone who understood the evidentiary value of what she was describing. Samuel Whitfield's office submitted its own certification confirming the date of the will's execution and the complete timeline of the estate proceedings, establishing beyond dispute that Joseph's estate had been fully arranged and legally completed after the divorce decree had taken effect. The argument Diana had been building was not just legally weak. It was now demonstrably predicated on a timeline that the documentary record contradicted at every relevant point. Adrian Voss separated from the matter quietly and with some urgency. He retained his own attorney, distinct from the firm bearing his name, and submitted a declaration stating that his involvement in the estate motion had been limited to legal representation and that he had no personal financial interest in the outcome. The declaration was careful in the way that documents written under legal pressure tend to be, comprehensive in what it addressed, deliberate in what it did not. Carter read it twice and filed it without comment. He understood what it meant. Voss had calculated the risk, determined that solidarity with Diana was no longer in his interest, and made the rational choice. The structure that had held them together for years fractured at precisely the moment it faced real consequence. There was a civil hearing before a federal magistrate 6 weeks after Carter's filings. Elijah sat at the plaintiff's table in a gray suit, his hands folded on the table, his expression the same one he had worn in every difficult room in his life, composed, attentive, entirely contained. Diana sat at the defense table across the aisle. He had not been in a room with her since the original divorce proceedings. He did not look at her directly, but he was aware of her in the peripheral way you are always aware of someone whose decisions have significantly shaped your life. During the lunch recess in the wide marble corridor outside the courtroom, they were momentarily without attorneys between them. Diana looked at him. He looked at her. Nothing was said. It was, he thought afterward, the most honest exchange they had ever had. The magistrate issued her ruling 4 weeks after the hearing. Diana's motion to place a hold on the estate was denied in full. The estate proceedings were cleared to proceed without restriction. The court found no legal basis for classifying an anticipated inheritance from an estranged parent with no documented prior communication of intent to the beneficiary as marital property subject to division. The ruling on the civil fraud complaint was referred for further proceedings, with the court noting that the evidentiary record raised sufficient concern to warrant formal discovery. The final sentence of the ruling recommended the matter be referred to the appropriate state attorney's office for consideration of criminal charges arising from the document alteration evidence. Carter read that sentence to Elijah over the phone. Elijah said nothing for a moment. Then he said, "Thank you." He meant it for Carter. He also meant it privately and without saying so for Joseph. 3 months after the court's ruling, on a morning in October when Denver was cold and bright, Elijah drove to a cemetery on the eastern edge of the city. He had not called ahead. There was no one to call. He walked across the grass with his hands in his jacket pockets and stood in front of the stone for a while. He had not prepared anything to say. He stood there long enough for a pair of birds to land nearby and leave again, and then he said one sentence, softly and without drama. He did not report what the sentence was to anyone. That part was not for the record. He had read the letter again on the flight home from Denver, the handwritten page from the cream stationery. Joseph had written, "I watched you rebuild. I was proud of the way you did it. I should have told you that while I still could." Elijah had sat with those 3 sentences for the duration of the flight and had come to a particular kind of understanding that was difficult to name but easy to recognize. The understanding that arrives when you realize someone cared more than they managed to show, and that the failure of expression is not the same as the absence of feeling. He could be angry about the years of silence, and part of him was. He could be grateful for what Joseph had done with the years he had left, and part of him was that too. He decided to hold both things without resolving them. The legal matters continued to work their way through the proper channels, as legal matters do, slowly, procedurally, without drama. Diana's criminal exposure from the document alteration was real, and the state attorney's office had indicated it intended to pursue the case. Adrian Voss had cooperated with investigators to a degree that suggested he had concluded cooperation was preferable to solidarity. The details of what followed belonged to courts and prosecutors rather than to Elijah, who had made a deliberate decision not to spend his attention on Diana's circumstances when he could spend it on his own. He started a new company in the spring. A small one, a 2-person operation initially, focused on civil engineering consultation for nonprofit construction projects and municipal infrastructure work. He chose a name that did not include the word Hartwell. Carter remained his attorney and, more usefully, his friend, the same friend who had sat across a kitchen table at 7 in the morning and driven to Denver without hesitation and filed 40 pages of legal counter-argument in 48 hours on no sleep. Grace Monroe accepted a position as a compliance officer with a firm that Carter's office recommended, and she was good at it in the way she had been good at everything, quietly, precisely, without needing acknowledgement. Elijah hired a 3rd person in the summer and moved the office to a slightly larger space, 1 floor up in the same building. The window faced a courtyard. He considered that an improvement. He was not a wealthy man who looked like a wealthy man. He drove the same practical car. He ate lunch at his desk most days. He had $50,200,000 in a managed estate account and lived in a manner that suggested to any casual observer that he probably did not. What Diana had never understood, what she had planned around and studied and calculated for, and still never grasped, was that Elijah Hartwell had never been motivated by accumulation. He had been motivated by the work, and by the life built around the work, and by the people who showed up reliably in both. Joseph had understood that. He had understood it from a distance of 200 miles and 14 years of silence, and he had spent what time he had left making sure the understanding counted for something. Most people, when they thought about inheritance, thought about what was handed down. Joseph had handed down something that couldn't be deposited anywhere, proof that the right person had been watching and that they had chosen, in the end, not to look away. In the end, that was the inheritance that mattered. The money was simply proof that someone had been paying attention.